Kathy Allen, and my consulting firm is Audit Conduct. I provide training and consultation to CPAs and others on the accountant's professional ethics responsibilities, including auditor independence. Today I'll be talking to you about Noclar. Noclar means non-compliance with laws and regulations. It's the subject of a standard released and adopted by the IESBA, which stands for International Ethics Standards Board for Accountants. The IESBA is the ethics standard setting body of the IFAC, and the IFAC is the International Federation of Accountants. This is a very significant change in the IESBA code, and the reason being is that it allows an accountant who discovers Noclar, non-compliance with laws and regulations, in the context of a professional engagement to, in certain extreme circumstances, disclose that non-compliance to an outside regulator without the client's consent. This was the subject of my fall newsletter, and I'll be talking briefly in this video about the IESBA standard, about the AICPA proposed Noclar standard, as well as some of the comments that came back on that proposal. So what is the IESBA Noclar ethics standard? It's basically a response framework that requires the accountant to take certain actions upon discovering non-compliance. Now there's a few key points to keep in mind regarding the IESBA rule. First of all, it is always the job of management and possibly the board of directors to resolve and attend to the non-compliance. That is not the accountant's job. That's number one. Secondly, the standard covers a variety of laws and regulations, including securities laws, laws dealing with money laundering, corruption, tax law, and pension law. And the accountant is not expected to be able to recognize all instances of Noclar. In other words, he or she is responsible for recognizing Noclar when it falls within his or her professional expertise, experience, and background. And lastly, and this is a really important point about the standard, is that nowhere in the IESBA standard is the accountant required to seek out and find Noclar. This is a framework that applies once the accountant becomes aware of it, but again, does not have to go searching for it. So at this point you may be asking yourself, how does the IESBA Noclar standard apply to me? I only practice within the United States. Well, the AICPA, along with many other professional accountancy bodies throughout the world, are members of the IFAC. And as a member of IFAC, those organizations agree to adopt professional standards that are at least as strict as the IFAC standards. And this is in order to enhance the quality and consistency of professional standards throughout the world. So once the IESBA adopted a Noclar standard, the AICPA appointed a task force to look into the issue. And in March 2017, AICPA's Professional Ethics Executive Committee proposed their own Noclar standard. What exactly does the IESBA Noclar standard require? Well, first you should know that the standard is tailored so that depending on an accountant's role in an engagement or at a client, it differs. The four types of accountants covered in the standard include auditors, non-auditors, members in business who are in senior roles, and members in business who are in more junior roles in their organization. And just generally speaking, the required actions go something like this. First of all, the accountant must gain a good understanding of the facts and ensure that there actually is non-compliance at play. Secondly, if that is the case, he or she should communicate the Noclar to the appropriate parties within management and possibly also to the board of directors or a similar body. Later, the accountant should evaluate actions that management has taken or possibly not taken to address the non-compliance, and based on that evaluation, determine whether further steps are needed under the circumstances. Now, in the most extreme instances where the accountant has credible evidence that the public is being harmed or would be harmed by the non-compliance, that is where the Noclar provision allows the accountant to consider the possibility of going to an outside regulator with those facts without gaining the client's consent to do so. So let's talk now about the AICPA's Noclar proposal. This was quite similar to the IESBA standard, but it departed in two significant ways. First, the standard was generally similar for both auditors and non-auditors, and this was different from the approach the IESBA took. Secondly, the AICPA's proposal excluded any mention of a provision that would allow the accountant to think about going to an outside regulator when, for instance, there was credible evidence of significant harm to the public interest and the accountant noted that management was not resolving the Noclar. And if you look at the IESBA standard, it does defer to local law. Because it's in a global standard to be implemented throughout the world, it has to do that. And so when Peak released its proposal, its reasoning for excluding that provision was that the majority of the state accountancy boards and the AICPA code prohibit an accountant from disclosing Noclar in those circumstances. The only circumstance under the Peak's proposal that would allow an accountant to make such disclosure would be where there was a law or regulation that required it. So, for example, Section 10A under the securities laws. So what was the reaction to the AICPA proposal? It was pretty mixed, although there was agreement in principle and with parts of the proposal. The most frequent comment was that the Peak should not treat auditors and non-auditors similarly. And the reason given generally was that non-auditors don't have the same access to management and the board of directors. They play a very different role than auditors do, a lesser role generally. And so they may not have the wherewithal to be able to carry out the responsibilities in the framework as an auditor would. The other comment that came back dealt with the confidentiality provision and whether the timing is good to take a look at that and determine whether maybe in the instance of Noclar, in certain circumstances, confidentiality should be able to be overridden by an accountant. And in all likelihood, because this involves state board rules, AICPA would need to work with the State Boards of Accountancy and the National Association of State Boards of Accountancy, or NASBA, in order to make any kind of progress in that regard. So what is the right answer? No one would argue that CPAs should not keep their clients' and employers' information confidential. And there are a few exceptions under today's rule that would allow an accountant to do so. For instance, if you're subpoenaed to provide information, you override the confidentiality requirement. This Noclar situation may be another type of matter that would allow that, but I have no doubt in my mind that the profession will seek the proper balance between the duty of confidentiality and the duty to the public interest. To keep up with this and other developments in professional ethics, I invite you to visit my website at auditconduct.com, where you'll find my newsletters, blog posts, articles, and other resources on professional ethics and auditor independence. I'm Kathy Allen, and thank you for watching.